letter signed Robert B. James, District Attorney. So all of these charges, Mr. Newman has entered the plea, as I indicated, not guilty by reason of insanity. And so all of these charges, he is presumed innocent unless and until proven guilty in a court of law. You also have out with you a proposed verdict form, to which each of you must freely and voluntarily agree, and it must be reduced to writing, and you have the different options that are on here. And as to count one, malice murder, the jury finds the defendant, and you have an option of finding him not guilty by reason of insanity, guilty of mentally ill, or guilty. Also, the same options are present for count two, and you have an option of finding him not guilty by reason of insanity, guilty of mentally ill, or guilty. One of you will act as a foreperson at the appropriate time. You will sign it, print your name, and also write your jury number and the date in which you return the verdict, to which all of you freely and voluntarily agree. You will have those documents out with you to record whatever decision that you make. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in charge to the facts as you find them to be. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains for the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is charged is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of evidence, a lack of evidence, or a conflict in evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you will be authorized to convict the defendant. If the state fails to prove the defendant guilt beyond a reasonable doubt, it will be your duty to acquit the defendant. The law provides that criminal action shall be tried in the county in which the crime was committed. Venue, that is, that the crime was committed in DeKalb County, is a judicial fact that must be proven by the state beyond a reasonable doubt, just as any element of the offense. Venue must be proved by direct or circumstantial evidence or both. The defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of the state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or acts and conduct, or it may, in your discretion, inferred when it is a natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. The defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, or other circumstances connected with the act for which the accused is being prosecuted. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference is a matter solely within the discretion of the jury. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all the testimony of the witnesses and any exhibits submitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness, such as by person observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with that fact or elimination of other facts. There is no legal difference in the weight you shall give either direct or circumstantial evidence. You will be authorized to convict only if the evidence, whether direct or circumstantial or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. Now, parties have entered into stipulations that have been approved by the court about certain facts, circumstances, and documents. Where parties stipulate facts, that is, in the nature of evidence, you may take that fact as those facts as given without the necessity of further proof. You make all decisions based on the evidence in this case. Where parties stipulate testimony, documents, or exhibits only, this is in the nature of evidence. You may take that testimony as if given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony or other evidence. You make all decisions based on the evidence in this case. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The jury must determine the credibility of witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as your juror. Testimony has been given by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimonies when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The credibility of a witness may be attacked by disproving the facts to which the witness testified. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged you regarding credibility of witnesses. Some, but not all, of the factors you may consider in assessing reliability of identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have had, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator, and the length of time between the crime and the out-of-court identification. It is for you to say whether, under the evidence in this case, the testimony of the witnesses, and the facts and circumstances of this case sufficiently identify the defendant beyond a reasonable doubt as the perpetrator of the alleged crime. It is not necessary that the defendant show that another person committed the alleged offenses. If you do not believe that the defendant has been sufficiently identified as a person who committed the alleged crimes, or if you have a reasonable doubt about such, then it will be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of the defendant as the person who committed the crimes alleged in this bill of indictment. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. To be voluntary, a statement must be freely and willingly without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be a product of a free will and not under compulsion of any necessity imposed by others. In determining voluntariness, you may also consider to what extent the defendant was informed of his rights as discussed below. You may consider the legality, duration, and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and voluntarily made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement officer as follows. The defendant has a right to remain silent. If the defendant chooses not to remain silent, anything he said could be used as evidence against the defendant in court. The defendant had a right to consult with a lawyer before any questioning and to have the lawyer present with him at all times during any questions. And if the defendant did not have money for a lawyer would have been provided to him to represent him before any questioning and to be present with him during any questioning. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given and that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all the warnings as to the defendant's constitutional rights were given, and that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules of testing the believability of the witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find the defendant was properly informed of these rights and that he understood and gave up these rights, you must disregard the statement entirely and give no consideration in reaching the verdict. A person commits murder when that person unlawfully and with malice aforethought, either expressed or implied, causes the death of another human being. Express malice is that deliberate intention unlawfully to take away the life of another human being, which is shown by external circumstances capable of proof. Malice may, but need not, be implied when no considerable provocation appears and when all the circumstances of the killing show an abandoned and malignant heart. It is for the jury to decide whether or not the facts and circumstances of this case show malice. To constitute murder, the homicide must have been committed with malice. Legal malice is not necessarily ill will or hatred, but it is the unlawful intention to kill without justification, excuse, or mitigation. If a killing is done with malice, no matter how short a time the malicious intent may have existed, such killing constitutes murder. Georgia law does not require premeditation, and no particular length of time is required for malice to be generated in the mind of a person. It may be formed in a moment, and instantly a mortal wound may be inflicted. Yet, if malice is in the mind of the accused at the time of the doing of the act or killing, and moves the accused to do it, such is sufficient to constitute the homicide as murder. Proof of particular motive is not essential to constitute the crime of murder. Evidence of motive, if any, is omitted for your determination as to whether or not it establishes the state of the defendant's mind at the time of the alleged homicide. A person commits the offense of possession of a firearm during commission of a crime when the person has on or within arm's reach of his person a firearm during commission of any attempt to commit a felony, which is any crime against or involving the person of another. Every person is presumed to be of sound mind and discretion. However, this presumption may be rebutted. If you find that at the time of the alleged criminal act the defendant was suffering from insanity or mental illness, then you shall determine whether the defendant is not guilty by reason of insanity, guilty beyond a reasonable doubt, or guilty beyond a reasonable doubt but mentally ill. The law makes a distinction between being insane at the time of the commission of the alleged criminal act and being mentally ill at the time of the alleged act. Therefore, it is necessary that you understand this distinction. A person shall not be found guilty of a crime if at the time of the act, omission or negligence constituting the crime, that person did not have capacity to distinguish between right and wrong in relation to an act, omission, or negligence. In regard to the question of insanity or insanity at the time of the alleged criminal act, there is a test to determine whether the person is suffering such a degree of insanity that the person is not capable of committing a crime. The test is whether the insanity was such that it deprived that person of the mental capacity to distinguish between right and wrong in relation to the act, omission, or negligence that the person allegedly committed. The perpetrator may be what is commonly referred to as insane in a loose and general sense, yet in the eyes of the law, he may be sane and responsible so far as the act in question is concerned if, at the time of the commission of the alleged act, the accused has sufficient capacity to distinguish between the right and the wrong of the particular act. This is a question of fact to be determined by you. Mere weak-mindedness, mental abnormality, mild retardation, or mental state shown only by repeated and unlawful antisocial conduct which does not amount to insanity is not a defense to a crime if the person had the mental capacity to distinguish between right and wrong in relation to the alleged offense when the alleged offense was committed. Insanity may only be a temporary malady, and if the accused did not have sufficient mental capacity to distinguish between right and wrong with reference to the act alleged in this indictment at the time that the act was committed, then the accused would not be criminally responsible. The test of criminal responsibility is the condition of the mind of the accused at the time of the commission of the alleged act. If a person of unsound mind has intervals of understanding during which that person can distinguish between the right and the wrong of a particular act, then that person shall answer for that act if it was committed during those periods of understanding. If, due to an affliction of the mind, a person's mind is so impaired that the person is incapable of forming the intent to commit the act with which he is charged, or to understand that a certain consequence would likely result from the act, then that person would not be criminally responsible for the act. The defendant has the burden of proving insanity by a preponderance of the evidence. If you believe beyond a reasonable doubt that the defendant committed the act charged in this bill of indictment, but also believe by a preponderance of the evidence that at the time of the commission of this act, the defendant was mentally incapable of distinguishing between right and wrong regarding this particular act, then it will be your duty to acquit the defendant because of insanity. I have already defined what beyond a reasonable doubt means. Now, let me tell you what preponderance of the evidence means. It means evidence on the issue involved that which, not enough to free the mind from a reasonable doubt, is yet sufficient to incline a reasonable and impartial mind to one side of the issue rather than the other. If you find the defendant not guilty by reason of insanity, then you must specify this on your verdict and the deliberation cease. In that event, the form of your verdict will be, we, the jury, find the defendant not guilty by reason of insanity. Should you find the defendant not guilty by reason of insanity at the time of the crime, the defendant will be committed to a state mental health facility until such time, if ever, the court is satisfied that he should be released pursuant to law. There is an exception to the rule that I have given you. If a person has reason sufficient to distinguish between right and wrong as to a particular act about to be committed, but because of some mental delusion, the person's will was overpowered so that there was no criminal intent to commit the act in question, that person cannot be held criminally responsible for that act. In that regard, a person shall not be found guilty of a crime when, at the time of the act, omission, or negligence constituting a crime, that person, because of mental disease, injury, or congenital deficiency, acted because of a delusional compulsion that overpowered the person's will to resist committing the crime. However, a person who suffers from periodic mental delusions may not intentionally and voluntarily induce delusion or mental disorder and then be excused from the commission of a criminal act committed during the delusional episode. If such a person intentionally and voluntarily induces the delusion with the intent and expectation that the conduct during the delusional episode will be excused because of the delusion, and while under the influence of the induced delusion that person commits a criminal act, then the person is criminally responsible for the criminal act. In order for mental delusion or delusional compulsion to constitute a defense, it must appear not only that the accused was actually laboring under a delusion at the time of the commission of the alleged criminal act, but that the alleged criminal act itself was connected with the particular delusion under which the accused was then laboring, and that the delusion was as to the fact that, if true, would have justified the alleged act by the accused. This is a question of fact to be determined by you. A person is justified in threatening and using force against another person when, and to the extent that he reasonably believes that such threat or force is necessary to defend himself or a third person against the other's intimate use of unlawful force. A person is justified in using force that is intended or likely to cause death or great bodily harm only if that person reasonably believes that such force is necessary to prevent death or great bodily injury to himself or a third person, or to prevent the commission of a forceful felony. The state has the burden of proving beyond a reasonable doubt that the defendant was not justified. If you believe that the defendant committed the act charged in this bill of indictment, but at that time the defendant was actually laboring under a mental delusion, and that the act was connected with that delusion, and that the delusion was as to a fact that, if true, would have justified the alleged act by the accused, then you should find the defendant not guilty because of insanity. In this event, your deliberations will cease, and the form of your verdict will be, we, the jury, find the defendant not guilty by reason of insanity. I charge you that should you find the defendant not guilty by reason of insanity at the time of the crime, the defendant will be committed to a state mental health facility until such time, if ever, that the court is satisfied that he should be released pursuant to law. If, and only if, you do not find the defendant not guilty by reason of insanity, then you may consider whether or not the defendant was mentally ill. As to being mentally ill at the time of the act alleged in the indictment, the term mentally ill means having a disorder of thought or mood that sufficiently impairs judgment, behavior, capacity to recognize reality, or ability to cope with the ordinary demands of life. The term mentally ill does not include a mental state shown only by repeated unlawful antisocial conduct. Under the evidence and the court's instructions, if you believe beyond a reasonable doubt that the defendant is guilty and was mentally ill at the time the commission of the offense, then you will be authorized to find the defendant guilty but mentally ill at the time of the crime. If this is your finding, then you must specify it in your verdict, and the form of your verdict would be, we, the jury, find the defendant guilty but mentally ill at the time of the crime. I charge you that should you find the defendant guilty but mentally ill at the time of the crime, the defendant will be placed in the custody of the Department of Corrections, which will have the responsibility for the evaluation and treatment of the mental health needs of the defendant, which may include, at the discretion of the Department of Corrections, referral to temporary hospitalization at a facility operated by the Department of Behavioral Health and Developmental Disabilities. As any evidence as to the sanity, insanity, mental illness of the defendant is to be considered by you along with all the other evidence in this case. If the evidence as a whole raises a reasonable doubt as to the defendant's guilt, the doubt must be resolved in favor of the accused. By no ruling or comment that the court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Now, one of your first duties in the jury room will be to select one of your number to act as a foreperson who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You must start your deliberation with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in DeKalb County, Georgia, did, on or about November 18, 2010, did commit the offense of malice, murder, or possession of a firearm during commission of a felony, you should be authorized to find the defendant guilty. In that event, the form of your verdict will be, we, the jury, find the defendant guilty. Or, should you find and believe beyond a reasonable doubt the defendant is guilty but mentally ill at the time of the commission of the alleged offenses, the form of your verdict will be, we, the jury, find the defendant guilty beyond a reasonable doubt but mentally ill. If you do not believe that the defendant is guilty, or if you have a reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant, in which event the form of your verdict will be, we, the jury, find the defendant not guilty. Or, if you find and believe beyond a reasonable doubt that the defendant committed the acts charged in this bill of indictment, but also believe by the preponderance of the evidence that at the time of the commission of the acts charged in this bill of indictment, the defendant was mentally incapable of distinguishing between right and wrong regarding these particular acts, then it will be your duty to acquit the defendant because of insanity. The form of your verdict will then be, we, the jury, find the defendant not guilty by reason of insanity. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in this charge. You will not show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment. Now, whatever your verdict is, it must be unanimous. The verdict must be in writing and signed. Have a seat, lawyers and parties. All right. Any exceptions for the state?
No exceptions from the state, Your Honor.
Defense?
Just as previously discussed, Judge, I think it was States 41, which Your Honor read about the delusional component and justification. We did object to that previously in defense number 21, which the state objected to, and that was regarding who determines the release of the defendant. That was ordered.
So noted. All right, Kelly, we're still on record. Lawyers, our normal procedure with the alternates, I normally just bring them out and put them on call. I know some judges let them remain in the courtroom, but since they've taken an oath not to talk about the case, allow them to talk about the case with anyone. These are smart people. They've always been competent, and I've been doing this for the last 12 plus years. I always put them on call. I haven't had a problem with that. Any reason why I should not follow my protocol?
Not from the state, Your Honor.
No.
No. So, lawyers, what I would do is bring them in, give them instruction not to discuss this, allow anyone to discuss the case with them. I think it's a waste of time to have them just wait around the building, so I let them go on their way with the understanding they can return here within 1 hour. Their notes will be kept here. Their notes will not leave the building, and if they have to be put on the jury, I'll bring them in, give them instruction at one time, and the jury will restart their deliberations if they're added, and their notes will be given to them. Also, let me go ahead and do this before Deputy Gary brings them in. The items that the lawyers agree will be going out with the jury, can you go ahead and put those behind Kelly now before I bring them in? That way, once that is done, you come on up, lawyers. Moore, if you could bring them in, please. Those alternates in the hallway. All right, Lord, boys, you may be seated. Jurors number 66 and 67. Now, first of all, thank you very much for your patience and your diligence and your positive attitude. I know you've been working with me for the whole month while we're so far. At this point in time, you're the alternates, but your job is not done yet. What I normally do is let the alternates be on call, and that way you don't have to just sit and wait for building. I was thinking a complete waste of time because you take an oath, you aren't going to discuss case, allow anyone to discuss case with you. So what I normally do is allow you to leave, go about your business. Deputy Moore will give you your communication advice. Now, he's going to also have an envelope. What's going to go inside that envelope are your notes. Nobody's going to look at your notes but you. Also, what you're going to write on that envelope, on the outside, you can just write your juror number. Just write your juror number, 66 and 60 on the outside. Now, on the inside flap, this is going to be a little different. Go ahead and write down your name and write down a password, I use the term password, that only you recognize, because now you're going to write down a telephone number where you can answer the phone. What's going to take place, I'm going to put you on call. I'm going to let you leave the building today and tomorrow, or however long it takes. And you will get a call at some point from one of my assistants. And my assistant will use that password. Now, if someone calls you and telling you they're from the court and they use that password, hang up the phone and call 911 because somebody else is harassing you, okay? So they're going to have to use your telephone number, your name, and that password. And only my assistant is going to have that information. Follow me? So write down a word, don't write down your name again. Just write down something that you will remember, okay? Now, that person, when they call you, they're going to give you some instruction. Either A, they're going to thank you for your time and that your services are no longer needed, or if they call you, they're going to tell you, we need you to come on back in. Now, if I release you for today and tomorrow, or how long it takes, can you give me some assurance that you can get here within 1 hour of a telephone call? Is that yes? Wonderful. So you can go anywhere you want to within a 1 hour radius. Now, and that's a real one. And that 1 hour includes parking your car, coming to the motor tent, coming back inside. So you really don't have an hour distance. You only get about 15 minutes. Because if you, like when I came in the day back from the month, the elevator wasn't working. So I had to factor that in. I had to find a different way to get upstairs, which is okay. So you have to factor in all that time. Again, thank you very much for your patience. Thank you for your time. You're still on the jury. I'm just not going to keep you in the building, okay? So go ahead and, like I said, put your number on the outside. On the inside flat, which you're going to fold down and you're going to close up. Put your name, a telephone number, and a password that only you and my assistant will know. And you're going to put your notes on the inside. Deputy Moore is going to hold on to your jury badges. That way you won't have to physically come back in. But somebody's going to contact you one way or the other. They're going to either tell you, A, thank you for your time, or B, come on back in. All right, any questions? Wonderful. Hearing none. You've been great positive attitude. Like I said, don't forget, name, telephone number, and password, and close the flat. Yeah, put your number there. Now, jurors 66 and 67, do you have any other personal items there in the jury? Okay, Deputy Moore is going to go back in there with you, let you get your personal items, but don't talk to the other jurors at this point in time. And he's going to let you select your phone. And if you could, select your phone. Don't take somebody else's telephone. Just take your phone. Any questions? But he's going to go back in. And if you need some animal crackers to go, you can get your little bag to go to. So you take care of all those things. Great. So, do not go to work today. And my preference is, if possible, do not go, stay on call all day tomorrow. So don't go. Now, if you work at a job where I'm not going to call you, somebody's going to call you. If you stop what you're doing and get here within 1 hour, you can go to work. But I don't want you to go to work. I prefer for you to do what you know. How do you do it? You can go shopping, you can go cut down a tree, do what you want to do. As long as you keep your phone. Now, this time I need you to keep your phone with you. Keep it on vibrate or keep it on audio. But if you get a number from this courthouse, I need you to answer that phone. We're not calling to say how you do. I need you to answer that phone. Okay? And they're going to give you that information. Any questions? Again, thank you for your time. Thank you for your service. Like I said, you're free. Enjoy the rest of the afternoon. I think the sun was shining when I came in. You're more than welcome to enjoy the sunshine. But however, do not discuss this. Allow anyone to discuss this with you at this point in time. Do not give any interviews. Hopefully you won't have that problem. Do not go on the internet and do any research. Same rules apply. Although I'm letting you go right now, and it's relatively early, do not consume any alcohol, because if I have to call you to come back, I need you to come back with a clear mind. We're clear? So now, after 6 o'clock tonight, go ahead and let your hair down and relax. But don't let it down so low that you can't get up and function tomorrow. Okay? All right, have a good evening. Thank you. Deputy Garrison, let you be through your Fridays. Thank you very much. And please take your phone, because that way we'll have someone saying you get their phone. All right, thank you, Deputy Moore. You can be seated. All right, lawyers, if you can come on up, and lawyers, the items that you agree should go out to the jury, and you agree on, if you could put them on that ball right in front of the jury bench, the microphone.
They're all there.
Everything's there already? Wonderful. Have the state and the defense, both, all 6 lawyers, had a chance to go through the proposed evidence that's going to go out to the jury?
Yes, Your Honor.
Yes.
All right. Lawyers, anything else as far as before this evidence goes out and they start their delivery? Anything else from the state?
No, Your Honor.
Anything else from the defense? All right. What I'm going to do, lawyers, I'm going to go ahead and let the indictment go out. I'll take my yellow sticker out, and the proposed verdict form will go out. And we're off the record, Kelly.